Well, hey, have you ever wondered what you're signing whenever you sign the agreement of purchase and sale? Do you really have any idea? Well, I guess first of all, your realtor should actually explain what it is you're signing. So that's part of their job, and that's what I'm here for. So I'm going to kind of go over the agreement of purchase and sale, but just part of. I'm going to go over the first two pages of it. There's a lot more that's involved, but I think we should digest this in smaller chunks. So on the very first page of the agreement of purchase and sale, doesn't matter whether you're using a realtor or whether you're doing a private sale, you always have the first page, which has the price and a few terms and stuff and closing and stuff like that. So we're going to quickly go over this. So first of all, right here you can see there's a date of the agreement of purchase and sale was made. So you need a date, so that's for reference, so you know when it was started. Then you need a buyer. I've had people say, well, listen, why do I need to put my name on there? Well, you need it on there so the seller knows who is buying the property, and then the lawyer knows who to register the property to whenever it closes. So that's that. Then we move on to the property address. Obviously, you need that because you need to know exactly what property you're buying. Then you need to put in the property size. So you need to, so if it's approximately 500 feet in frontage and 1,000 feet in depth, then you know the approximate size of the lot. Now, really, you're not going to know dead on unless you actually get a current survey, which really needs to be done now. Because if you have an old survey, sometimes the things could have changed. So it's best to have a current one. A lot of properties don't sell with surveys, but that's for a whole nother day. That's a whole nother topic. So then you need to put a legal address. This way, your lawyer has some form of legal description so that he can do a title search on it. And we're going to talk about that on another video, not today. Then you need to have the purchase price. You have to have a purchase price. Again, I've actually had a buyer say to me, no, I just leave it blank and let the seller put in whatever he wants. Well, that's like signing him a blank check. So it's a good idea that you actually put a number in there. So it's not very often I've had that, but actually I have had that asked to me. So yes, you do need to put a number in there. Then you need to discuss the deposit. So you don't have to put a deposit, but it's a very, 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 very good idea. Because if you don't offer a deposit as a buyer to the seller's going to go, why would I accept that offer? He's got nothing invested. So he doesn't put it. Here's the thing. The buyer doesn't put a deposit down. It's held up. You got a firm deal. It's supposed to close, say at the end of the month, end of April. So in the meantime, the guy could have sold the property 15 more times. But at the end of the day, the buyer goes, you know what? I didn't put a deposit down. I'm not going to close. I have nothing invested in this, so I'm not going to close. I'm not going to lose any money. But all of a sudden, if he has $10,000 or 15 or 20 or 100,000 or $10,000, whatever the number is, he's got more invested. So he's lot less likely to walk away. We have seen deals where people have walked away, but I don't know. Money's hard to come by these days. You've got to work hard for it, so less likely they're going to walk away. So it shows good faith that they are going to indeed, that's their intention to close. Then you need to decide, where is that deposit going to be held? You can't just give that deposit to the seller because he can spend the money and then he doesn't close the deal. So you need to put that money in trust. So typically, not always, but typically it goes to the listing brokerage. It can go to the buyer's brokerage, not very often, and it can also go to the seller's lawyer or the buyer's lawyer. It can go to whoever you guys negotiate, whether it's the buyer or seller. They negotiate where it goes. But you do need to put it in trust so that money is held until the day it closes. Then that money is applied to the purchase price, because that money really shouldn't be touched. As if it's in the real estate brokerage, they can't touch it until the day it closes, or the day the deal falls apart because of a condition can't be met or something. But we're getting ahead of ourselves. I'm getting ahead of myself. So we'll talk about that on another day. So that's talking about your where the money is held. That is your money as a buyer. It's held. It should be held in trust. So the other thing is, there's down here where it says schedules, you could have a Schedule B, which could be just something attached to the agreement of purchase and sale, such as like a survey. That could be a Schedule B. The Schedule A, where that says right there, the Schedule A, that's where all your conditions are. And we're going to talk about that on another day. We're not going to get ahead of ourselves today. Then we need an irrevocable. So the irrevocable is usually given by the person making the offer. So the buyer is the one that made the offer. They're the ones that are giving the offer essentially to the seller and saying, hey, listen, we're giving you until 6 p.m. on the 15th day of April to reply back to us. Now the seller has a choice. He could just say, not going to work with it. Not even going to sign it back. It's way too much money. I can't accept that much. Yeah, right. Wouldn't we all wish that that was the case? So he has until then. Now the buyer can't go and back out of that offer because he's actually made the offer and he's signing under seal, because on part of the agreement of purchase sale, I think it's number 28 or something. But we're going to go over that again. Get ahead of myself. We're going to talk about signing under seal as well. So anyways, so that's when the seller has to sign back by. If he does not sign back, nothing happens, as if the offer never even happened. Then you need to have a completion date. I've actually had buyers say to me, listen, I don't need to put a condition or a completion date, just whenever the seller wants to close. Well, the seller needs to know when you would like to close. So then maybe the seller might go, you know what? I had really hoped for a, say for a September closing, which is, a bunch of months out for now. But listen, the guy's given me lots of money, so I'm going to let him close on the day he wants. So therefore, you have to put a date. You have to some kind of a date, and it's all negotiable. So you put down April 29th, that's the closing date, but the seller might go, no, I want May 29th because they need a little more than just 2 weeks to get out. So that's all negotiable. So that's the completion date. You need to put that in there. Then there's notices, right? So you need to know where a notice is going to go. So say there's further in the offer, there's some conditions to be met, and the conditions upon financing. Well, then when the buyer needs to send the condition of finance that he's either fulfilled it or is waiving it, there's two different things. It's two different things. So if he sends a notice of fulfillment to the buyer's or to the seller's agent, he can sign it and say, because if there's two different brokerages. Now, if we're talking about the same brokerage as the listing brokerage and the buying brokerage, and it's the same brokerage, that's a whole nother conversation. We're going to get into that later, but I can't. It's just too much right now. I don't want your heads to explode. So, anyways, so that just to state that a condition or some kind of notice, some kind of piece of paper has been sent to the other brokerage, and they are acknowledging it. They can't. The agents, the realtors cannot make any changes to an offer or amendments or anything. They cannot make changes. Only the buyer and seller can. That's it. So then we move on to chattels included. So chattels included are basically, fridge, stove, washer, dryer, all that kind of stuff. That sort of thing. Things that are not nailed down to the property. Basically, my kind of rule of thumb when I list a property is I say, basically, Mr. Seller, take the house turn it upside down. Whatever's fastened stays. Whatever doesn't, if it falls, that means it goes. Or can go. So that's why we need to put chattels included. So if Mr. Buyer, in this case it's B. Uer, yeah, B. Uer, that's who we got here. If Mr. B. Uer wants the stainless steel Bosch gas stove in the apartment, he needs to write it down, because otherwise it's deemed to never exist. So he never put it in. If he doesn't write it down, that means Mr. Seller can take it. Mr. Eller can take it with him. So make sure you're fairly specific. If you don't care, if they're old appliances, just put fridge, stove, washer, dryer, whatever, and you don't care. Who cares? But if you care and you want that stainless steel Bosch stove because that thing's worth $2,000, make sure you write it. You can even go as far as put as much details as you want, even put the serial number on there and take some pictures. The other thing is fixtures excluded. So say, you have an 8-foot high by 4-foot wide antique mirror in the front entryway, and you want to take that take it with you, Mr. Eller. Well, then you need to put it in here, because otherwise the seller or the buyer might think that he's getting that because it's screwed to the wall. Keep it from falling. So yeah, write that down. Anything, absolutely anything that you want to take that is fixed or fastened or not sure of, make sure that you write that in as an exclusion. The next thing that's really important, because this is a bone of contention with a lot of buyers, so rental items. I don't care what it is. It could be your furnace. It could be your water heater, water softener, water purifier. It could be a propane tank. It could be, I don't know, it could be anything. Lots of things are rented these days. Even furniture are rented now. Anyways, so we see a lot of furnaces that are being rented now. So what I say is make sure you put the details in there, and also put in there that the details or the contract will be provided during the conditional period, so that the buyer can look at it and go, hey, wait a minute, Mr. Seller, you said that this is $50 a month and ending June 2022. Well, all of a sudden you look at the contract, it's not ending till June 2028. So because there's furnaces can be on the property, put a lien. It actually can be liened against the property. So when your lawyer goes to do a title search, can't close because there's a $15,000 lien against the property from the furnace. You want to know those details. So listen, that's a real good reason why you want to hire a real good lawyer and a real good realtor who can help you figure these things out. The next thing I want to bring to your attention is HST. There are different rules that apply for different properties. Typically, now I'm going to say typical because I'll base this off my experience, and I've been in this a long time. So typically, a resale in real estate, a home, not a business, not a property that is a registered business owner or a corporation that owns a property. That's a whole different conversation. You always should consult your accountant when it comes to the agreement of purchase and sale if you're not sure about the HST. Typically, though, in a resale, it is included in. You do not have to pay that. So there are instances that you do. And let's face it, at the end of the day, on closing, you don't want to pay another 13% as a buyer. So for every $100,000, you're paying another $13,000 in HST. So make sure you know. So anyways, that's all I'm getting into for today. It's already too much because there's a lot involved. We're going to get into the rest of the agreement of purchase and sale in the next video. So until then, if you got any questions, by all means, give me a call or give me a shout, send me a message, put a message down below. I don't care. Subscribe, like, and share all this video as well. So anyways, until next time, have yourself a great day. And until then, I'm pulling for you. Have yourself a great day. Take care. Oh, and by the way, I'm Joseph Talbot, real estate broker in the beautiful southern Georgian Bay area in Ontario. Until next time, take care. Bye.